Hello, everybody, and thank you for joining me on this very chilly night, this very chilly Wednesday night. Rowan, thank you so much for organizing this session. Rowan, I know that you're on board. Can you hear me?
Yes, good evening, Ivor. Thank you very much for speaking to us as optometrists, not just only our group, but all optometrists and some other business people. So we're very glad to see you. Good evening to you.
Thank you so much. And look, I'm going to get straight to it because it is an evening, and I don't want to waste the time of those people involved. I asked Ruan to organize a get together of the members of his group and other optometrists in the country so that we can talk about the fact that the South African Independent Tenants Association is launching a legal challenge against landlords in general. And when we say landlords in general, as our tenant members sign up, and remember, there's no cost to joining SAITA until October, but as our tenant members sign up, what we are going to do is we're going to launch a legal challenge for three particular reasons. The foundation of the legal challenge is that we are saying that whereas tenants are subject to the disaster regulations, we believe squarely that landlords should equally be subject to the disaster regulations, and therefore that landlords have no right to act over and above the law when tenants are subject to the law. What we mean by that is that as tenants, you are responsible, you were responsible during the lockdown period for not trading. The government said to you, please don't trade. Here are the terms of disaster. And in fact, if you were essential service, you were very, very severely restrained or constrained in terms of what you could do as essential services. Our researchers determined, and we have roughly about 680 members around the country, but our researchers determined that where essential services were trading, that on average, those essential services were doing in the region of between 15 and 20% of their normal turnover because of the constraints on what essential services actually meant for them. So, what we're doing is we are going to court and we are saying to the court, we please want a directive, we want an order from you to the effect that if a landlord has said that even though a tenant is restrained from trading, the shopping center nevertheless is entitled to collect rent, even if it's partial rent, that there's something insidious, something malicious, something illegal about that. And we want the court to decide. And it's around this concept of force majeure, the idea of an act of God. And in this instance, there wasn't an act of God. In this instance, it was the directive by the government that caused you to shut down and not be able to trade or trade under very restrained essential service conditions. But that in that instance, everybody is affected by that act of God, and that landlords cannot somehow contract themselves out of being affected by the act of God, and therefore the impact of those disaster regulations. We think we're on a very solid footing. We have not just attorneys and senior counsel involved in this challenge, but we also have academic lawyers involved in this challenge. And in fact, our academic research has managed to go back to the early 1900s, where the law of force majeure under the British and the Afrikaners in South Africa was first established, believe it or not, in our legal system, where in fact, insurance companies as early as the 1900s were having to deal with this issue of force majeure. So we're very lucky in that we have a number of academic lawyers involved in this process and giving us opinions as to force majeure. We know that the Constitutional Court is very favorably inclined towards these kinds of arguments and has ruled on these issues previously. But we know that to get to the Constitutional Court, we have to go through the High Court, where we have a very confident feeling that we will succeed in the High Court, but that the landlords will throw everything they can at a challenge against the High Court ruling to the Appeal Court in Bloemfontein. And once the Appeal Court in Bloemfontein has ruled, even when they rule in our favor, only then are we entitled to approach the Constitutional Court. So it's a three-legged challenge, which, by the way, is very much in your favor as a tenant, and I'll get to that in a minute. But we're going to the Constitutional Court. And the reason we're going to the Constitutional Court is for the following reason. We know that there will be additional pandemics, and we know that additional pandemics might result in a lockdown or some other kind of intermediate kind of action that will prevent you from trading or at least restrict how you're going to trade in the future. We also know that we're facing massive climate change and climate upheaval, which again will cause business interruption in your business. Remember, we're not looking at this from an insurance point of view. That'll be a separate action down the line. But it will cause business interruption. It will cause you to have to close your doors, even if for a short period of time, and you will lose business. It will cause your shopping center to have to close as well, as is happening regularly and has been happening over the last 2 weeks because of the liberalization and the opening up of the business community. So in one way or another, it's going to affect your business. And we need the Constitutional Court to say that when that happens, if you're restricted from trading, you should not have to pay rent. Now, we're not saying you should not have to pay the non-rental elements of what you owe the landlord. We're adamant about the fact that you need to pay for water and for lights, and you need to pay for common property costs and operational expenses that ordinarily would be levied against you unless we're able to challenge that individually on a landlord and tenant by landlord and tenant basis. But what we are saying is that your invoice, your monthly invoice, is divided into two sections: non-rental charges and rental charges. We're saying you're going to have to pay the rental charges, but as far as the non-rental charges are concerned, we're going to ask the court for a directive in this regard. And we do not believe that 50% discount that landlords give you, or anything other than 100% discount for the lockdown period, in terms of rental payments, is acceptable. We do not believe in the moral justification of a deferment, because all a deferment means is, I'm going to get my money from you, but I'm just going to have to wait longer. And you know what? I might even charge you interest in the process. And if the lease makes allowance for penalties, I might even charge penalties on those unpaid debts until such time as I get the full amount of money back from you. So a landlord is sitting pretty, because a landlord who's given no discount and only deferment knows that he might have to wait 6 months, but he's going to get his money, which is against the disaster fund regulations, because disaster fund regulations is what good for the goose is good for the gander. If you're ordered to lock down, you're ordered to lock down. If your business is not an essential service, you can't trade. So we are asking the court, and we're going to be asking the Constitutional Court to make a decision on that element, the rental payments during lockdown. Number one. Number two, we're going to be asking the courts the following. We're going to be saying to the courts, there is this thing that we are defining called the recovery period. We can show for a fact that there is a variation for at least the next 6 months to a year after that a lockdown has been lifted. And remember, lockdown hasn't been lifted in South Africa. We're still in stage 3. But the notion is, even if you're back in trading, there is this idea that there's a recovery period. And it's going to take between 6 months to a year for you to get back to, and this is important, for you to get back to the average turnover that you were doing July to December 2019. The average turnover that you were doing July to December 2019. And what we're going to say to the courts, and we want the court to rule on this, is that at least for a recovery period after a lockdown, you should be charged a percentage of turnover rent rather than fixed rental. Now, I know that in your industry, on the service side of your industry, rather than the product side of your industry, there are some of you who might be nervous about this, because you might very well find that a percentage of turnover when you're fully trading, that a percentage of turnover when you're fully trading might in fact be in excess, more than what your current rental agreement says you have to pay in rent. When we go to court, we're going to go to court and say, please, we want a percentage of turnover levied. We'd like your view on whether or not a percentage of turnover is the only fair and solid way of determining what our clients should be paying until such time as what they're paying as a percentage of turnover meets what they were paying as fixed rentals doesn't exceed what they were paying as fixed rentals, or alternatively, 6 months to 12 months has expired, we have a relatively good feeling that we won't get our 12 months, but certainly we'll get a period of that time defined as the recovery period. This very much is going to be argued as a dispute of interest and not a dispute of rights, because this issue has not been argued in the court of law on the scale and with the intensity that we're intending to argue it. But if we manage to get precedent in both of those instances, it will mean, number one, that you as a business will not have to pay rent during the period that you're not trading or making turnover. And number two, that thereafter you'll be entitled to a recovery period, which may end up being stipulated in your future leases as 3 months and not 6 months or a year, it doesn't matter, but that during that period you would be charged a percentage of turnover instead of a fixed rental, and a percentage of turnover up to a maximum of what you were paying as fixed rentals in your normal lease agreement. So those are the two things we are going to ask from the Constitutional Court eventually, but initially from the High Court, to rule on in our favor. Now, the big advantage, there's a third thing as well. We want all penalties and we want all interest that you might have been charged during this period of time, which is the lockdown plus the recovery period, reversed. And we're asking for an order of remission, which means that either if you haven't yet paid the rental element of your bills, then you shouldn't have to, or if you have, but you have a lease that's operating, you should be credited for the full value of that remission. That's what you're asking for. The massive advantage of your participating in this legal action against your landlords is that the moment this legal action is launched, you will be in a position to be covered. You'll be in a position to be covered by the fact that your landlord cannot take legal action against you for the period under review, which is the period of the lockdown and the period of recovery. That's not to say that your landlord won't be able to take action against you for the non-rental payments that may have not been made, or for the fact, and we're finding that in 37% of the cases we're dealing with, the tenants have outstanding debt from before the lockdown. And we can't do anything about that except to possibly get you some kind of a deferment for the repayment of that outstanding debt. And we've been very successful in doing that on a tenant landlord by tenant landlord basis. We've been going for 8 weeks now. This is a critically important action for all tenants, large and small in this country, because it doesn't just define what's going to happen for this period, which is COVID-19, but for future pandemics, for future business interruption, and importantly, it defines laws such as what is a recovery period. So it deals with a whole series of interest disputes rather than rights disputes. A right dispute is something that happens after the interest or the law has been resolved. We want as many tenants as possible to sign up to this action. We've determined we need 100 to launch the action, which will be in the High Court and get us as well to the Court of Appeal in Bloemfontein if necessary. And that in total, we will need 375 tenants to have signed up for us to get through the Constitutional Court. It is highly unlikely that the Constitutional Court will give us an order of costs should we win. And equally, it is unlikely that the Constitutional Court will give the other side the order of costs because this is new law, should we lose. The total financial exposure that you would incur as a single footprint, the total financial exposure that you would incur as a single footprint is 4,000 Rand. To participate in the entire action, it's not going to cost you 4,000 Rand. It's not going to cost you more than 4,000 Rand. It's a once-off total financial exposure. And what you get for that is, number one, you get covered legally so that until the matter's fully resolved, which means going through the High Court, going through the Appeal Court, and going through the Constitutional Court, if it's necessary, until the matter is fully resolved. At the stage where there is an order of court, which is not thereafter appealable or appealed against, until that matter is resolved, we will protect you from your landlord pursuing against you for the rental elements of the period under review, which essentially will be anything from 2 months to 8 months, depending on how we succeed along the way. And like I say, we're very comfortable with what our action is about and how we think it will go in court. We're not cocksure because you never know what's going to happen. But the most you have to lose here is 4,000 Rand. And the best you have to gain is most probably a mindset holiday for the full period of all three of those court cases, which could be 3 years or 4 years. But also the chance of getting the money back that you might have already paid for April and May. And as you know, that will be a lot more than 4,000 Rand. And equally, having defined the notion of a percentage of turnover to determine what you should pay during the recovery period after business interruption, which is a major, major win. And that's why I asked Ruan for an opportunity to address you and explain to you. The reason we're launching this action is we've spent the last 2 months, 3 months now, trying to deal with landlords. And landlords, because they are primarily in SAPOA, SA Rights, or the South African Shopping Centre Council, as associations, which together have formed the, and I kid you not, PIGS, the Property Industry Group, have taken a very dim view of tenants who do less than 80 million Rand a year turnover, 80 million Rand a year turnover in their actual proposals. The proposals do not deal with tenants doing 20 or 30 million Rand a year turnover. They don't even acknowledge that you exist. And we want to change that. We have attempted to deal with landlords. We have had 18% success on behalf, 18% success. And the reason is that landlords do not have to do anything here because no one's challenging them. And they have a signed lease agreement and they have surety to that lease agreement. And we think that that's an imbalance of power. And it's that imbalance of power we're trying to address here. So in a nutshell, that's what the South African Independent Tenants Association is doing. And Ruan, I don't know, we can take questions and we can hopefully have some kind of answers now. Let me have a look at what people have asked on the chat facility. Do you have an opinion on the proposed actions, applications, and may we have access to it? Henk, absolutely. I will send you a link. I'll send it to Ruan, a link for you to register to participate in our scheme. You won't be asked to pay the 4,000 Rand up front. You will only be invoiced for the 4,000 Rand when we have our first 100 participating tenants. So you will only be invoiced for your 4,000 Rand, and that's all you will have to pay when we have our first 100 participating tenants. Your payments, by the way, are not made to SAITA, your South African Independent Tenants Association. Your payments are made directly to our legal trust fund run by our legal team. So it doesn't come through SAITA, it goes directly through the legal trust fund. Yes, we really do want you to participate. Where do you intend to institute these proceedings? Henk, we will institute these proceedings most probably in the High Court in Cape Town to start off with, and then obviously make it a pervasive national action. What are the costs involved? 4,000 Rand once off, if successful for the participation. And what are the costs involved in the event of the application being unsuccessful? Well, Henk, we will be exposed for 4,000 Rand per tenant. We believe that, we know that when there is a dispute of interest and not a dispute of right, that dispute of interest will not result in any costs being granted by any of the orders of court. Who are the applicants in the matter? The applicants in the matter will be SAITA, that's the South African Independent Tenants Association, on behalf of the following list of clients, citing the following lists of landlords in the process. By the way, you are also avoiding being victimized for participating in this action or asking any kind of questions that ordinarily might endanger your lease by participating in an action of this nature. A landlord is not allowed to victimize or marginalize you. If they don't want to renew your lease, they have to give you sound reasons that have absolutely nothing to do with this action. And we're not naive enough to think that they can't find or make up other reasons, but we will certainly be in a very strong position to defend you against those reasons. How do you guarantee a capped 4,000 exposure? Because we give you that guarantee that your exposure is limited to 4,000 Rand and anything else will be covered within the course of the system. What would be a fair percentage of turnover to pay? Well, the average percentage of turnover is anywhere from 4 to 8%. 4 to 8%. 4% for those businesses that would be making a lot more turnover than a higher percentage might mean you have to pay in rent vis-a-vis those people who are charged fixed rent. So it's anything from 4 to 8%, and it's obviously would be negotiable. No court would make a substantive declaration. No court would come out and say it needs to be 4 or 6 or 7 or 8%. They would simply define and describe and prescribe a procedural mechanism for landlord and tenant to determine what a fair percentage of turnover might be during the recovery period. I needn't tell you that our medium to long-term objective for those businesses that do not want a fixed rental is to have the option of the landlord having to give you a percentage of turnover lease overall. Because as far as we're concerned, as far as SAITA, the South African Independent Tenants Association, is concerned, that is the only fair way of charging you rent and sharing the risk with the landlord. Number one, that the shopping center is working. And number two, that anything can happen to disrupt the business. And therefore, that the only fair way to go is a percentage of turnover, which would affect how your landlord charges you and shares the risk with you. So we think that that's quite important. And that's the medium to long-term objective, because it'll be the first time that the court actively would consider this notion, and therefore would be a dispute of interest. Okay, I think I've answered the questions. Right. Sorry, Ruan has a question. What do we do from now onwards with the landlords? Well, what you do now is we want you to try and organize with your landlords the best you can get out of them. So there are many landlords who have given from 25 to about 50% of discount for April. Some of them even 100% discount for April. They've given about 20 to 50% discount for May, depending on whether you're trading or not. And then most landlords have said, right, well, then we'll just give a certain amount of deferment, averaging at 25% of deferment. And many landlords have said, we'll give 25% of deferment for the recovery period for a 6-month period. So landlords have already recognized the recovery period. So 25% deferment, which means you'll only pay 75% and the other 25% will split over 6 months. So they'll still get their money, but they've tried in their own funny ways to be honest and fair. We've had that about 20% of the time in our dealings with landlords, that they've given fair agreements if they were entitled to be collecting rent in the first place, which we're maintaining they're not. So we want you to get the best kind of deal, and we will tell you, and we already are. Number one, we're negotiating on behalf of a number of our tenant members at SAITA, and as I say, we're 18% effective of getting deals, and about 20% of those deals are really good deals. The other 80% are weird deals. You have some very weird landlords out there. So for example, I spoke to a couple of tenants today who've been made an offer of 50% remission for April, even though you were completely closed, and 25% remission for May, even though most guys were still completely closed, in exchange for a lease extension of 3 years with escalation. Now imagine you're a judge in the High Court, in the Appeal Court, or in the Constitutional Court, where on the one hand there are the disaster regulations, and on the other hand, the judge is presented with a lease addendum or extension that says, in exchange for 2 months of somewhat aid or relief, this landlord wanted a 3-year extension of the lease with escalation each year. Imagine you're a judge being asked to decide in this world of ours in this world of human rights of ours, a charter of Bill of Rights that we have in South Africa in terms of our constitution. I don't want to overstate the case or overplay the case, but I hope you can understand what I'm saying here. So we will continue, Ruan, to negotiate on behalf of our members who want us to negotiate on their behalf. But equally, if you decide to negotiate on your own behalf, we'll lead you. We'll review the addendum as it's presented to you. We'll give you advice on it. We still want you to get the best deal. But the reality is we will be going for remission of any of your payments. So either you only pay the non-rental elements, you don't sign an addendum, you only pay the non-rental elements, you don't pay the rental elements, you join our action, and there is a wall around you, there's a ring fence around you until the legal matters are resolved. Or you pay what you agreed to with your landlord in the notion or in the understanding that when there is a legal resolution, you will be enjoying the benefits of remission, which is either a credit for what you've already paid or the money back itself, or a writing off of the debt if you haven't yet made any kind of payment. I do need to say, and I have had this question asked of me, what if there's a court judgment, but your landlord in particular decides he's not going to abide by the court judgment? Well, there's two answers, or two components of the answer. The first is, if there's a court judgment which has set precedent, and it's constitutional court precedent that we're looking for, and a landlord decides he's not going to abide by that court judgment, he's going to look for some kind of an exception to the court judgment, then we have a firm of attorneys who will be handling the legal matter for us in the beginning to get the court judgments, who will then take up the matter for you on an individual basis. Obviously, you'll have to pay separately if your landlord has to be enforced or if your landlord has to be coerced to respect the court judgment. But we have the legal team that's ready for each of those tenants who have that kind of a problem, either collectively, in other words, there's more than one tenant in a shopping center, or collectively, there's more than one tenant throughout the country who has a case with the same landlord, same property owners, or all of those property owners that we have problems with all belong to one particular association, for example, South African Property Owners Association or SA Right, or in fact the South African Shopping Centre Council. And then it will be a group action against them. And the bigger the action, the more participants, the cheaper it becomes. But that is only for the landlords who decide, even though there's a court ruling, we're not going to follow the court ruling. Be, quite frankly, stupid. It'll be ill-advised, but it is going to happen. We have no doubt about that. But generally, we think that if your landlord, after a long and weary 2, 3, 4-year battle, is staring down the face of a legal decision, he will come to the party. We have no doubt that the majority of landlords will want to settle and bide, or rather, not no doubt, but we have a hope that the majority of landlords will come to see reason without us having to go the full hog. We will also, by the way, consider citing the Department of Trade and Industry in this action as a respondent, because it's the Department of Trade and Industry who set this ball in motion. They did what we call a block release, which allowed the landlords and the tenants to form associations where ordinarily they might not be allowed to form associations like we're talking now because of the Competition Commission, which also falls under the Minister of Trade and Industry, having rules that say, you can't collude or collaborate. But they did a block release allowing that to happen. And we have it on record from the DTI that the reason they did that is they wanted landlords to get together and to organize together. They wanted tenants to organize together so that they could sit across the table and negotiate a better lease and rental provision than they've got in the time of COVID. And that hasn't been done. In fact, the landlords have simply colluded amongst themselves to keep tenants away from the table rather than inviting them to the table. And unfortunately, the Department of Trade and Industry set this ball in motion, but has done nothing to facilitate it, has done nothing to make it happen. And for that reason, we will strongly consider citing the Minister of Trade and Industry as one of the respondents in this action, because there's a lot that's left unsaid, and the impact is only on you, the tenants. Now, I know that some of you are not retail, But those retail optometrists around the table, we are seeing a decimation of retail business in South Africa, where just because of the losses of 3 months, you're not able to recover even though you're able to trade. And we think that this action, someone said to me the other day, why is this action not going to court on the basis of urgency? Number one, we've not ruled out the notion of going to court on the basis of urgency. But number two, we have a pretty good feeling that the court might say that because the majority of these disputes are disputes of interest and not disputes of rights, there are no rights to allege to argue for urgency. So we're in a catch-22. There's very little law around these areas that has been settled. And so we're going to have to do the settling. You're going to have to do the settling. And now I'm going to say something that's going to make me very, very unpopular. And I apologize for saying this, but please just try and understand where it's coming from. 8 weeks ago, when we started this, we realized that you were all bound to leases which were unfair. They were ridiculously unfair. They had clauses in them which were, quite frankly, stupid. But you collectively signed those leases. So the whip that was made for your back was of your own making. In law, we say caveat emptor, let the signer beware. And most of you who are retail tenants are not lawyers. And some of you, in fact, we're finding a large degree were advised by accountants and bookkeepers to sign these leases and business advisors, but not lawyers. What we're also finding is that 20% of our tenant members had their leases reviewed by lawyers who told them to sign those leases because the power imbalance with very large landlords and very small tenants, independent tenants, is such that you wouldn't be able to get into a shopping center unless you made those compromises. You might be asking yourself the following question. You might be asking yourself, how complicit, or rather how negligent, was my business advisor who negotiated the lease for me? And Henk, I really do apologize. But how complicit was my business advisor in getting this lease for me and asking me to sign this lease in the first place? Or at least how negligent? Does that person have indemnification insurance? And maybe if I'm going to suffer leases, if I'm going to suffer some kind of damage, is my business advisor was my business advisor or my accountant or my bookkeeper or even my lawyer negligent enough to put me in a very bad position by recommending I sign that lease? Now, SAITA is not taking that matter up. That's not our issue at this moment in time. In fact, if we were looking for negligence, we would, and we are considering launching a second court action that has nothing to do with this matter against landlords, a second court action against insurance companies. Because we really honestly believe that insurance companies have contracted out of the responsibility for business interruption cover when they shouldn't be allowed to. But that's a different issue. But these are all issues you need to consider. Good. The legal team is headed up by Peter Bierski, who is a veteran of law and a very successful veteran of law in Cape Town. His business practice was started in 1960, believe it or not by him, obviously. And the reality is it's a strong legal team. We have 2 senior counsel on that legal team, and we have another firm of attorneys, Trisos and Associates as well, who are participating in this action with us. One of the things that we have had to do is be very specific. And by the way, as I said, we have a number of academic lawyers who specialize in property and commercial matters as well. But the difficulty has been all along that whoever is on that team cannot be in the pockets of landlords or SAPOA, SA Rights, and the South African Shopping Centre Council, or in fact PIGS as it is now. And the problem is that the vast majority of lawyers in South Africa have always had to depend on conveyancing and property commercial matters to survive. So we've had to do a lot of digging and a lot of consulting, I would say, with senior counsel as well in the process. All right. And Jana says, what should you do if landlords are not responding to emails and haven't given any relief? And Jana, I would do this. So in legal principle, What you want to do is you want to be on the right side of the law, but at the same time, you don't want to overexpose yourself in terms of what your financial payments might have been. So I would start off certainly by paying all of your non-rental costs of your invoice, which are water, lights, rates, taxes, any commercial levies for security, etc. All of the non-rental elements. And I would certainly pay those things. I wouldn't not pay those elements. Because the reality is, even if you're prevented from being in the shopping center, the right argument is that the shopping center has to survive so that there's something for you to come back to. It's a little bit like if your children are not going to school, the most ridiculous thing you could do is stop paying your school fees. Because when your child is ready to go back to school, they're not going to be teachers or facilities or a property for them to go back to. So understand it from that perspective. But the rental element of your lease is where, through no fault of their own, your landlords are in breach of their own leases because they cannot give you access, or during the lockdown period, they couldn't give you unfettered access to the property they were renting to you, that they were selling to you, the access they were selling to you. And so as a result, we're maintaining that once you're covered by this action, you wouldn't necessarily have to pay those rental elements, but you would certainly have to pay the non-rental elements of your lease agreement. Although we are saying to you, if your landlord offers you a 50 or 100% remission or discount, then do the balance, especially if it's been deferred. Do the balance, because it's a good deal you're getting under the circumstances of your lease. We are not saying act as if we already have an order of remission. But once we have an order of remission, it will become retroactive on whatever you've paid in terms of earning you credit or earning you repayment, or in fact forgiving debts that haven't been paid in that regard. So we're saying to you, and Jana, get the best deal you can from your landlord. Now, you might have found that you asked SAITA previously to approach your landlord, and we would have done that. But the reality is most landlords would have preferred to have dealt with you, and in your lease agreement, there would have been a clause to say that you can't join an association, which, by the way, is also against the Constitution. You can't join an association, etc. They have to deal with you individually, even though their managing agents will deal with you and the lawyers of their managing agents will deal with you. They created this unfair relationship where you wouldn't be allowed representation or affiliation. So they might want to deal with you personally, but they might give you a good deal in dealing with you personally. So get the best deal you can, either through SAITA or dealing with them individually that you can, in the knowledge that the moment you join this action, number one, we inform them of the fact that you've joined the action and you're covered for the period under review. So they shouldn't be touching you for that period under review. And number two, in the idea that you will get something back at the end of the day because we will want to be successful. Good. Ruan, I'm acutely aware of the fact that I didn't want this to be more than half an hour. We've gone slightly over. Are there any other questions or anything I can answer for you? And I'm only choosing you because you've organized this for us, sir.
Can you hear me? Yes, I think it's just one question. Keith asked for one and said, could be lining up or associating with SAITA possibly have a negative effect on your future lease negotiations? And that's, I think, in the back of the optometrist's minds.
So the reality is this, that if we can prove any kind of if your lease says that you're entitled to extend your lease and you are in good standing, in other words, before COVID, you had no debts, you paid all your rentals on time, etc., etc. Your landlord is not allowed to invoke your behavior during the time of COVID to restrict you from having an access to right of renewal as far as your lease is concerned. And if they do, then there's a separate action against them for doing that. Having said that, human nature says that your landlord might try to victimize you. Your managing agent may try to victimize you. And that's why we have SAITA, because SAITA then comes in and we prove victimization. Your landlord's not going to want to go to court if we can prove victimization. I can guarantee you that. So your landlord has to have a very good reason not to allow you to renew your lease. If he's renewed your lease 2 or 3 times previously, you're in good standing with him. The only time your landlord will not renew your lease is if you're not in good standing with them. So you haven't paid them on time, or I need to say this as well, and I'm terribly sorry to bring this to your attention. But we found that, and certainly just in terms of our inspection, we found that there's also roughly about 15% of our tenants who are in excess of 4 months of unpaid bills. And we're talking about going back beyond February, so from February backwards. There is no reason, if you owe 4 months, 6 months, in some instances 10 months that your landlord has forgiven, of components of your rental bill, major components very often that you haven't paid. There is no compunction, there's no reason for your landlord to be sympathetic to your cause in asking for aid or relief during the time of COVID. And certainly there's no reason for your landlord to want to renew your lease. So, Ruan, my answer to you is there might very well be victimization against those companies who are already in bad standing with the landlord and thereafter want this relief. Now, we're not stopping those companies from joining our SAITA action. We welcome everybody because our relief we're seeking is relating to a specific, very specific issue, which is lockdown and the recovery period. But in your instance, if there is an order of court and your landlord says, no, you weren't in good standing beforehand, why should we bear the order of court? There's no question that if we go to court, we'll get the court to impose the order of court, but at the same time, your landlord would be able to offset what he owes you as a credit for what you owe him and still claim against you for the balance. There's no question in my mind about that. So, Ruan, I'm certainly not saying that there couldn't be a negative consequence, but I'm saying, first of all, the cost is negligible, so that's not a risk. And secondly, when we send the legal papers to your landlord, it is simply to advise them that you are covered for that very specific period, that we seek a very positive relationship with them, and ideally we wouldn't have wanted to have gone to court in the first place. I can't really say more than that, but I hope that at least puts your mind at ease that you're in no worse a position should you join this action than, in fact, if you don't join the action.
Well, thank you, Ava. I think that's a practical. I think it makes sense to us. And I think there were like very good practical examples for us that make sense. It's common sense to follow. What is the process you'd like to follow for us to follow now? When is the deadline in joining
so
the class action?
There's no deadline in joining. I'm going to send you, by the way, we call it a group action, not a class action, because there's a whole different legal connotation to a class action. I'm going to send you a link for registration. So those companies that do want to register, it's an 18-question questionnaire. You'll fill in the questionnaire and submit it, which means you immediately become a member of the scheme. The scheme only becomes alive and active once we have our first 100 companies on board. If we do not have our first 100 companies on board, you pay nothing. You only get invoiced for that 4,000 Rand once we have confirmation that there are 100 companies that have joined us. To date, we have 58 companies that have joined us. Two of them, we had 60, two of them withdrew because they decided that they were simply going to close their doors for a variety of reasons and that they didn't physically want to participate in the action. So we have 58 of them, so we're 42 short. But like I said, this registration's only been open for 5 days now, so I'm quite happy with where we're going. So you will only be invoiced when we have our first 100, and the costs that we will have collected will cover us for the action in the High Court and action in the Appeal Court. And thereafter, we will continue to collect membership because our threshold that we need to achieve is 375 participating companies and members. By the way, I do have certain guarantees that should we reach our first 100 but not get to 200 but not 375, we'll have a certain number of guarantees in the system as well. But only those companies in the system who have registered will be covered by the system that we'll be enforcing against. Charlotte says, what happens if my lease was not formally renewed despite me asking a few times and my landlord's agents just continued an old lease arrangement? Well, that's on a month-by-month basis, Charlotte. This landlord is not giving me any relief except to allow a few months to pay off April in full, although I didn't trade. Well, Charlotte, you need to join this action, please. I'm begging you. You have 4,000 Rand to risk, which in your instance might be the cost of, one side of a pair of glasses. No, I'm just being funny. I just had a new pair of glasses made. The point I'm trying to make to you, it's 4,000 Rand, Charlotte. You are already on a month-to-month basis where you have no lease extension. Separately, I would like you to get hold of us so that SAITA can pick that up with your landlord in terms of a lease renewal. But at the moment, you operate on a month-to-month basis, and that's not security. Certainly not if you have to put your own resources into getting that business reestablished. Good. Ruan, thank you so much for the time and the opportunity. I love talking to your guys. I will send you the link for the registration. And please, I'm imploring you to be involved. It's in your best interest as a collective to be involved. But thank you so much for working with SAITA in this regard. I really appreciate it, sir.
From our side, thank you very much for putting time aside and making yourself available. And we will forward the information to all the other optometrists as well once you send us the link and a copy of this webinar.
Fantastic. Thank you so much, Ruan.
Thank you.